I appreciate y'all coming on in. Today has been a long time coming, long time coming. Facebook, YouTube, Twitter X. It's been a long time coming. I appreciate you guys for your support. We're out here. We're going to bring some new things, breaking news here in Chicago. It's a lot of things that's going on with us, with the rent situation. A lot of us have been through so many tricks with these landlords. And I'm trying to figure out who want to talk about it tonight. I really want to talk about it tonight. I appreciate you guys coming in. This is landlord versus tenant, or tenant versus landlord. These are, and we all know those that are property owners, and this is probably a smack against the face of property owners because it's hard. It's hard finding good tenants, and when you do get a good tenant, it's hard to keep them. Some folks don't want to pay. They'll pay their first month rent and security deposit, and they will not do anything. But there's a new ordinance going around here, and we want to find out what's going on, dig into it, and I want to hear some of you guys. What are your thoughts? What are your comments and stuff like that? What are some of your comments? We really want to talk about that. This is what we want to talk about. We want to talk about Chicago protecting our renters ordinance, House Bill 3564. Protect your home, protect your rights, rent stability, fairness, and dignity. And this is what you see on the screen here. It's what you see. And we know a lot of people be bogus when it comes to rent. We know it. We know it. We definitely know it. So come on in, come on in. This is your boy Martin G. You already know what it is. Uncut, unedited. Appreciate y'all for tuning in. And we're going to open up the lines 872-299-0808. I got a good half hour, 45 minutes in me tonight. Been working long hours, long days. And we appreciate Teamwork Inglewood tonight that's sponsoring this. I am a navigator for Teamwork Inglewood, and they do fight for people's rights. That's one thing we can say about that. All right, that's what we're looking at, people. Chicago Protecting Renters Ordinance, House Bill 3564. And we're going to talk about that tonight, and I want to see what y'all got to say. Because I know a lot of y'all probably behind in your rent or trying to find a place. It is hard. They want 3 times the rent money or 2 or 3 times, mostly 3 times. If they charging $1,000, you got to be making at least $3,000. I know I'm right. I know I'm right. You got to be making at least $3,000. They charging $5,000 a month. They want you to make at least $15,000 or $10,000. Real talk. You said, well, Martin, is it really people out here that's paying $5,000 a month for it? Yeah, it is people out there that's renting. Now, what you see on the screen is we're going to go through this chart right here. We're going to go through it, and we're about step by step. It's called the Chicago Protecting Renters Ordinance and House Bill 3564. These are the legislative updates you need to know. Advocate update. All right. We're not going to read everything, but we're going to go through some things briefly. Chicago Protecting Renters Ordinance. It's called PRO. Protecting Renters Ordinance. Explain. The status. Not yet formally introduced. Expecting direct introduction to the City Housing and Real Estate Committee this month. All right. The Johnson administration is proposing a sweeping overhaul of the residential landlord tenant ordinance, the RLTO, called Protecting Renters Ordinance, PRO. The ordinance is expected to be placed directly on the House and Real Estate Committee agenda, possibly June the 10th. bypassing the standard full council introduction. Now, this is considered an unusual move. Really, people, it is. That has already drawn pushback from all the persons. The realtors have been proactively educating elders and engaging Chicago media outlets on this ordinance, which is negatively impact Chicago multifamily housing. All right. It said for more information, check out these articles, news articles. Mayor Brandon pushing sweeping changes to renter laws and landlords. Mayor Johnson is introducing measures to protect Chicago renters. Now, these are some of the key provisions of concern include informal rent control framework. At the time of lease renewal, if a rent increase is deemed unconscionable by the tenant, they would have to right to reject and demand relocation payments of equaling 4 months rent or more. Wow. Security deposit caps, move-in fees restrictions. Oh, they hitting hard. Security deposits would be capped at 1 month's rent. Okay. So in other words, I think they're saying that if your rent is $1,500, your security deposit wouldn't be $3,500 or $3,000, if I say. All right. So, okay. Move-in fees are effectively prohibited. Oh, wow. They're knocking out the moving fees to avoid Chicago highly punitive security deposit. All right. Litigation environment. Okay. Many tenants see move-in fees as preferable to paying larger security deposits, some up front. Oh, wow. Look at this, man. Sweeping tenant bills of rights. The broad new tenant rights covering tenants organizing. Let me take these glasses off so I can see people. I'm sorry. I'm having a hard time. All right. Lease termination, retaliation claims, and quiet enjoyment while significantly expanding damages, penalties, attorney fees, and injunctions relief against housing providers. Man, they going in. Citywide, just cause eviction. Landlords must satisfy narrow and statutory grounds before recovering possession and may owe relocation assistance even for the owner move in. Wow. Family occupied or major rehabilitation applies even to the owner occupied 2 to 6 unit buildings. Wow. Encourage keys for cash negotiation. Wow. Okay, rather than navigate the formal eviction process while trying to recover their property, just cause requirements to create incentive for landlords to negotiate private buyout agreements with tenants. Similar policies in cities like San Francisco, where buyouts agreements sometimes reach 5 figures, have made cash for keys agreements. All right, commonplace for further driving up costs for housing providers. Significant financial exposure. Landlords may face 4 to 5 months of fair marketing, rent, and mandatory relocation payments and penalties, and plus attorney fees and litigation costs. Wow, man, it getting hard. What y'all think, people? What is going on here? What do you think, guys thinking? This is crazy. All right, this is crazy. What are you guys thinking? We need some call-ins because we got to talk about this. It's fairly new, and we need some callers. 872-299-0808. I need to know what you guys' opinion is about this. A lot of things have changed. Now, they don't have no really, to my knowledge, they don't have no rent cap on here. They can go up your rent $200, $300 and everything. Maybe this come in the perfect time around the Obama Library, those apartments and town houses, homes around there. Maybe this coming in perfect time. All right. Good evening, Kim. All right. Miss Moet Rose, I see you. Hey, how you doing? I need y'all to call in. Let's talk about this. 899-0808. Call in. Let's talk about it. Let's talk about it. Let's be about it. I want to know what's going on. We went over some things here. Just getting on. We're talking about Chicago. Chicago protecting renters. This is supposed to protect the renters. It's an ordinance. House Bill 3564. Protect your home. Protect your rights. Rent stability, fairness, and dignity. Wow. It's real talk, people. I want to talk about this. What's going on? Just getting on, okay? We talk about renters. Now, I'm kind of feeling sorry for some of y'all landlords, but it is what it is. Some of you landlords, you go up every year, a couple of $100, $200, $300. Then nobody say nothing. There's really no real cap on rent. Have you ever lived in a place where you paid your rent faithfully, you never late, and the landlord go up $150, $200? Not because of the tax went up, but it just, they do that. They do stuff like that to get you out. Now, according to this right here, we can talk about, let's talk about this. According to that, now it's protecting the renters. Now, we talked about, well, actually, I read a little bit about what's going on. These are some of the key provisions of concern. Include informal rent control framework, security deposit caps, move-in fees restrictions, sweeping tenant bills of rights, citywide just cause eviction, encourage cash for keys negotiation. Then the last one, it said significant financial exposure. Landlords may face 4 to 5 months of fair market rent and mandatory relocation payments and penalties, plus attorney fees and litigation costs. My God, they're not playing. All right. Let's talk about it. We're talking about House Bill 3564, rental housing application junk fees effective January 1, 2027. Status awaiting governor's signature effective January 1st, 2027. House Bill 3564, it regulates how housing providers charge and disclose fees to prospective and current tenants. Originally, this was a much more restrictive bill, which included a cap of security deposits and a full prohibition of both move-in fees and application fees. However, realtors worked with the bill sponsor, Senator Mike Simmons, and Representative Nibala, I think that's pronouncing her name, to substantially amend legislation. A trailer bill, HB 5234, passed with both chambers this past weekend, moving the effective date from July 1st, 2026 to January 1st, 2027. Wow. What the final bill requires. All non-optional fees must be disclosed on the front page of the lease and in any listing or advertising that includes the rent amount in a clear and conspicuous manner. Wow. People, there's a lot going on. Let's look at the application fee. Application fees may be charged, but must reflect the actual cost of the tenant screening, credit checks, background checks, and screening reports. Fees over $50 are only permitted, okay? If the actual third-party screening cost exceeds $50, the landlord pays the cost up front and bills the tenant within 14 days with a receipt. Prohibited duplicate screenings, fees exceeding actual costs, administrative add-ons, and any fee unrelated to the screening. I'm sorry. It's a ban on other fees during tenancy. Okay. Housing provider may not charge tenants for what? After hour maintenance request fees, contacting property management, calls, emails, maintenance requests. Wow, I didn't know they do that. Maintenance hotline, service call, or travel charges for repairs. Wow. Fees for routine maintenance and keep up. Pest control charges if the tenant did not cause the issue. Okay. Fees for eviction notice or filing prior to eviction ordering being entered. Wow, they going deep. Fees for in-person walks through and move in or move out. All right, look at here, man. It said, what did not change? The realtors, advocate move-in fees, and security deposit regulates preserve as if in the final bill, January 1, 2027. Effective date provides time for members to review lease templates and advertising practice and fees structures before the law takes effect. We encourage all members to consult with legal counsel to ensure compliance. Update to leases. Once signed by the governor, the effective date of these new regulations will be January 1st, 2027. Our Forms and Contracts Committee will make necessary updates to the 2027 lease and any other supporting documents to ensure they align with this new law. It's a lot going on. Where my callers at? I know it's a new law. Don't nobody know, but I had to bring it to y'all, let y'all know what's going on. I had to do it. This is real, people. It's real. So it's going to be a lot what the landlords can't do and what they can do. They said a ban, look at y'all, ban on other fees during tenancy. Housing providers may not charge tenants for. They can't charge you for this as of January 1, 2027. After hour maintenance request fees for contacting property management, calls, emails, maintenance requests, maintenance hotline, service call, or travel charges for repairs, fees for routine maintenance and upkeep, pest control charges if the tenant did not cause the issue, fees for eviction. Wow, that's going to be a major blow. Fees for eviction or filing prior to an eviction order being entered. Wow. Fees for a walk-in person through a move-in or move-out. Wow. I didn't know they charge fees for that. Wow. It's deep. This is deep, people. Protecting renters ordinance. All right, who want to call and talk about it? Let's call and talk about it. I need me some callers. What are you guys saying? I want some feedback. I want some feedback. All right, people. All right. All right. Somebody said, I'll say, we are doomed. I feel that this is a foreign country. USA is a land of foreigners. We are, as people of color, need to come together. Communist country for sure. I'm done to this. Okay. They said they are building a lot of affordable housing all over the city of Chicago. Meanwhile, Cabrini Greens has over 100 low-income apartments that have been boarded up for years. All right. All right. Somebody said that Benjamin said the city governments are responsible for 95% tax hike increases. Well, causes, effects of what happened to tenants. Now, people, what's going on here? Now that I got y'all attention, let's talk. Let's talk about it. Let's talk about it. This is live uncut. This is your boy Martin G, aka the Crime Chaser. It's a lot of things they're not gonna be able to do. So, man, I'm telling you, what I think that's going to happen. It's going to be a real strict process of a lot of landlords of putting in, allowing people to rent. Yeah, it's going to be a lot, really a lot. So it's a lot. We're taking calls 872-299-0808. Taking calls 872-299-0808. Let's talk. I want to hear from the tenants and the landlords, at least one and one. If you're a landlord, tell me what you think about this. Real talk. Real talk. Let me put it back on the screen so you guys can see. This is nothing Martin Johnson making up. I'm not making this stuff up. This is real. I'm not making it up. This is real. House Bill 3564. We talked about it. The key provisions of concern include informal rent control framework, security department deposit caps, move-in fees, restrictions, sweeping tenant bill of rights, citywide just cause eviction, encourage cash for keys negotiations, significant financial exposure. It's going to be a lot, man. Listen, they're going to be charging landlords to move you out. And it ain't going to be cheap. It's not going to be cheap. Landlords, y'all get ready. Get ready. There's some of y'all going to know for y'all renters out there. They're going to negotiate with you guys. They're going to give you keys for cash. Well, you got to get them keys or cash for keys. So in order to not to take you to court, they're just going to buy you out. And I think they can buy you up to like 4 or 5 months. They're going to buy you out, pay for everything. Man, they're gonna have people stop renting to people. We're going to have a whole lot of vacant apartments. What y'all think? Let me hear. I want to hear it. What do you guys think? I need some callers. 872-299-0808. I need some callers. Nobody wants to talk about this. It's live, uncut, unedited. This election time coming up. It's real talk. Let me put it on the screen. Maybe we could just walk through it. I'll walk through it one more time. Take my time. Walk through it. All right. Now, they got some articles up here. Now, what I read down here, what the final bill requires. Disclosure upfront fees. Application fee limits. Ban on other fees during tenancy. Okay, I got me a caller. Come on, dear sister.
Hey, Mark, I think truthfully, the city wants more money. I think it's a win situation for the tenant. The landlord.
Somebody got to turn their TV back. Yeah, turn your TV down.
Okay, I think it's a win for the tenants. The landlord is just going to have to be careful on who they rent for now. They're going to have to do a hard screening process.
Okay, hold it. My number is 872-299-0808. 872-299-0808. Go ahead, my dear sister.
I said they just gonna have to do a hard screening process. They just gonna have to make sure they get their rent money.
Ooh, it's gonna be tough. It's gonna be tough. Hold it, hold it right there. Come on, Buck. What you think?
Doing good evening, everyone. Good evening.
Good evening.
Is anything like it says just for Chicago or that's the United States?
Just Chicago.
Okay, well that explains a lot. Then they making it tough for that's gonna be about us. That's basically about black people. They don't really. They're making it so hard for to get rented a place to get a place. People can scrutinize you on all kind of things now, and they can always say it's because of this and that you're not qualified, but in the bottom line, they don't really want to have to deal with all that, and that's gonna make it hard for people just to find a place because without the way the jobs are, it's hard to save money to buy a house and all that. So renting is the best thing, and they're probably playing with Section 8, and they won't take that. And now it's going to be hard. It's going to displace a lot of people because the people want money that's really renting it, and then they want you to have some kind of, what they call it, references or something before they even try to even mess with you. So if you got some bad references of people you done left holding the bag and left moved out on them, left in the middle of the night, and they really ain't going to be wanting to take no chances. They want to make their money. And like I say, this don't make it no easier. And it seems like it's more for other people that's coming in our city. They want to get them an opportunity if they have cash money. And that they've been providing, them the way they have ability to have money in their hand with no time or no citizenship. And that's making it more evil for them. For black people, this might be a detriment to them because
you don't.
They got
Buck, so you don't think this will help black people or any poor people? What I read today? Because it's protecting the renters.
Yeah, it should. But like I said, you got to look at scrutiny on the people that own the buildings. And they're going to play, they can, it's been redlining for years where they wouldn't let us live in certain areas and they would always come up with an excuse. So this looks good for the tenants. But for the people who actually own the property, what does it make them say? They won't rent to them because they feel a certain way. So in my opinion, it's just me talking. I mean, it should help. But knowing people like I do, just this old school opinion, a lot of people that's about, trying to, they look for any reason to discriminate against us as black people. I ain't talking about no other people. I'm talking about no gay folks, no other people, no immigrants. We the only non-immigrants in America. And they will find a way to find this to be a detriment. They was, they had other laws of affirmative action, and they gave it to white women. So everything they say is supposed to be for us ain't always for us. It looks good on paperwork, but then get it enforced is another thing.
But okay, let me ask you guys a question. Now they put a cap on the security deposit, a lot of these fees, even eviction. Now it's going to be you could negotiate cash for keys. Even if the landlord, I believe if the landlord is at fault, if my memory's, he would have to pay for you to move. He would have to pay for you to move. Wow. Yeah. So it's a lot of stuff.
Sounds good if that's real, but they probably be glad if some tenants they had, if this is bad tenants, but if they made a mistake getting somebody in the building to pay for it, it's better than going to court. I can put it like that. Knowing the people that actually rented properties over the years, going through court, and then people that's real slick on that stuff. Every road running that script, they can't put them out in the wintertime or this and that, and they gonna run the game. But like I said, if they can pay them to get them out of there, that might make it easy to move around. But I think a landlord want to get somebody in there they can count on, but they looking at money. So back and forth trying to find somebody new, I don't think they might can do it. But if you get somebody that's solid and you ain't bringing their whole family and other people that's disruptive in your building or something, that's another situation. Because everything looks green on the outside, when they first initially get in there, then you having wild parties and teenagers disrupting the neighborhood.
Hold it. Now, let's go to some of these key provisions. It says an informal rent control framework at the time of lease renewal. Now, here we go. We just pretend like we're getting ready to get our lease renewed. If a increase is deemed unconscionable, now, other words, too high or ridiculous by a tenant, they would have the right to reject it and demand relocation payments equaling 4-month rent or more. Now, am I reading that right? Let me say it again. Yeah, man, look at this. Informal rent control. Let me slow down. Let me read it a little slow. Framework. At the time of lease renewal, if a rent increase is deemed unconscionable, I think I'm reading it correctly, by a tenant, they would have the right to reject it and demand relocation payments equaling 4 months rent or more. Wow. Did y'all hear that, landlords and tenants? Now, that's deep. I read that twice. Now, that's deep, bro. So, in other words,
that sounds like family justice.
Yeah, and that's like, hey, Buck, I'm your landlord, and you, I raise your rent up, and you say, no, that's too much. Now, you can reject it, and you could demand relocation payments equaling 4 months rent or more. Wow.
But that will kick a lot of slumlords out of there, because the cats that don't want to do nothing for the building, say you move in a building in a certain condition and everything starts deteriorating, and then they say, we want next time you renew, we want $300 more next time.
No,
and you say, hey, that ain't gonna happen.
Let's go to the second one. Security deposit caps. Move-in fee restrictions. Security deposits would be capped at 1 month's rent. So, in other words, if your rent is $1,500, they can't go over $1,500. And move-in fees. They said move-in fees effectively prohibited.
What did they say about the first month and security? They do that like the first
No,
month.
listen, Buck, I'm reading it now. Security deposits would be capped at 1 month's rent. So, some people charge 2 months security deposit and 1 month's rent.
Right.
So they can't do that anymore. And move-in fees are effectively prohibited. So you can't even charge a move-in fee now. That's prohibited. Many landlords began charging move-in fees to avoid Chicago highly punitive security deposit litigation environment. Other words, when you give a security deposit, they supposed to put that security deposit in the escrow, and they're supposed to gain interest. Okay. Many tenants see move-in fees as a preferable to paying larger security deposit sums up front. Wow. So let's see what this sweeping tenant bill of rights. Broad new. Go ahead.
Because a lot of times when you want to get out of there, they won't give you a security deposit back. I've been there. So they come up with any issues, all the need pain, you did this and the oven ain't working, anything. They come up with any kind of script. So go ahead.
Wow. Let me look at some of these comments. Okay. Wow. Okay. All right. Let me go back to this. Sweeping tenant bill of rights. Broad new tenant rights covering tenant organizations. Renting, withholding, lease termination, retaliation claims, and quiet enjoyment, while significantly expanding damages, penalties, attorney fees, and injunctive relief against housing providers. So I'm thinking, if I might read this correctly, broad new tenants' rights covering tenant organizations, withholding, lease termination, retaliation claims, and quiet enjoyment, while significantly expanding damages, penalties, attorney fees, and injunctive relief at the house providers. Now I'm trying to get the right interpretation because get the right language right here. All right. It said broad new tenant rights covering tenant organizations, rent withholding, lease terminations, retaliation claims, and quiet enjoyment while significantly expanding damage, penalties, attorney fees, and injunctive relief against housing providers. Wow. So I got to go back to that. I got to revisit this. That's a lot there.
You know what I see though, man? It sounds like they're giving people more options. A lot of
Yeah.
times when people get into a place, they're locking them in. This was just my own perspective. I say this sounds like even sports. You could be a free agent if you don't like the situation you're in, and you can like tell them if you're going to come out raising the rent. One of the things, your conditions, the rent increase or something like that, you can get you out of there quickly without losing anything. A lot of times they'll try to take you to court if you don't stay there. Somehow they'll try to force it. If you got like a lease agreement, they're trying to hold you to it. This way you can break the lease and sound like it.
Wow. It's real. Now, people, listen, I'm not an attorney. I'm not a lawyer. Let me just get that clear. I'm trying to read the language, get it right. So I don't want to send nobody off. So that's why I'm reading it slow over and over. So I'm trying to give the proper interpretation of what the verbiage is. That's what I'm trying to do. Right. Wow. It's deep, though. Okay. It's deep. All right. Citywide just cause eviction. Landlords may satisfy narrow statutory grounds before recovering possession and may owe relocation assistance even for owners, move-in, family, occupied, or major rehabilitation. Applies to owner, occupied, 2 to 6 unit buildings. Wow. Now, landlords may satisfy narrow statutory grounds before recovering possession and may owe relocation assistance even for the owner, move-in, family, occupied, or major rehabilitation. In other words, even if you get evicted, I'm assuming, before he recover possession, I guess I'm assuming, of the apartment, and may owe relocation. He may owe relocation fees. Wow. So even giving the apartment up, the owner still may have to give you a few dollars. That's deep.
A lot of cats ain't investing in that kind of business. They might take a second thought before they get into it, like getting property, because it's more freedom. It's like they giving more rights back to the tenants. It's like in family, after a million years, the people are suffering slumlords and other undue conditions. It's like they're giving something back to them. They help them, give them more flexibility, and with the economy like it is, that them 2 months down and all that stuff, people got to they wait till they get their income tax trying to move into place. So it's more, it's making things more affordable, I would say.
Ooh, yo, we see what it is, man. All right, now he got the last one down here. Encourage cash for keys negotiation. Rather than navigate the formal eviction process when trying to recover their property. So in other words, instead of taking you to court and all that, maybe do some negotiation. Just cause requirement. This is a just cause requirement. Create an incentive for landlords to negotiate private buyout agreements with tenants. In other words, instead of me taking you to go to court, you know what? Let me buy you out. I'm going to buy you out. Similar policies in cities like San Francisco, where buyout agreements sometimes reach 5 figures. Wow. Have made cash for keys arrangement. Wow. A commonplace. Further driving up costs for housing providers. Wow. Significant financial exposure. Landlords may face 4 to 5 months of fair market rent, mandatory relocation payments and penalties, plus attorney fees and litigation costs. Man, that is deep. Man, listen, y'all please comment. I know y'all didn't call in 872-299-0808. We're talking about the Illinois House Bill 3564, rental housing application and junk fees, effective January 2027. Because actually, it was going to go in effective tomorrow, July 1. So there's a lot going on. I understand a lot of people don't understand this. If they can't call in, I understand. I'm just learning it too.
It's, what you're reading, it sounds good because it's giving more.
Right.
It's not good for the landlords, okay, because they got to be more understanding to their people. If they ain't happy, then they got to help them get up out of there. But
yeah.
Unfortunately, we got some slick ones out here that's trying to, like you said, a brown keys for cash. People try to manipulate that situation for their own benefit. But hopefully, they have some kind of, guidelines where people just don't, get up in there and run a game and try to move around spot to spot and try to get a profit on it. But there's always some slick in the game out here as well. But for my opinion, I think it'll help more fairness. I mean, they should have came up with this like 100 years ago. Because slumlord is real in this world. People give it like these companies owned by I ain't gonna mention the name. I know they all over Chicago, and people try to find apartments and they own a lot of properties. And the stuff ain't much better. One ain't much better than the other.
Yeah.
So when people move around, they just going back to the same spot by the same people. They really run a lot of, and they ain't us. They back from the east over there. But they own a lot of properties in the city.
Right. Now, Jessica Martin says that, is it true that the landlord can owe tenants interest on their security deposit? Yes, that is true. Now, a lot of landlords get out of giving you security, taking security deposits by the move-in fees. So they're going to throw that out. No move-in fees at all. No move-in fees. They're supposed to put your security deposit in a special account, escrow account, where it draw interest. Yeah.
Did they say anything about background and credit checks on that?
Oh, yeah. Let me go back. It did. I read something earlier. Let's see how that works. All right, let's see. Okay. I did read something about that. Okay, here we go. Application, I believe this is it. Application fees. Limits. So they got a limit on that. Application fee may be charged, but reflect the actual cost of the tenant screening, credit checks, background check, screening reports. Fees over $50 are only permitted if the actually third-party screening cost exceeds $50. The landlord pays the cost up front and bills the tenant within 14 days with a receipt. Okay. Prohibited duplicate screenings, fees exceeding actual costs, administrative add-ons, and any fee unrelated to screening. All right, let's see. Okay, let's see. We're going to take this last caller. People. Okay. I think that's Bill. Yeah, go ahead, Bill. Go ahead.
Mark.
Thank you for calling, Bill. Hey, Bill, I'm struggling on this because this is new to me, Bill. I'm just reading this stuff and I'm trying to get the language right. Go ahead, Bill.
I agree with what Buck said. I've been listening about the last 30, 40 minutes. This is going to make most people hesitant about investing in
Mm-hmm.
the Chicago area because of all the stipulations. And I see this being in favor of these investment groups because most people that's buying 1 or 2 properties and trying to flip them and get Section 8 people in, because most people ain't dependent on somebody that is paying market value rent. And with it being a cap, that means if they only can get $1,500 when they had intentions or normally been getting $1,800 or $2,000. That's gonna cut a lot of people out.
Mm-hmm.
And the only people that could survive that is these investors. If they got 50 properties in Inglewood, if they got 50 in Lawndale, and they only making $300 to $500 profit, they can stand there because they got 150 properties across Chicago area, so they can survive that. But the guys that the ones we know, the black guys we know that's out here trying to do their thing and flipping properties and getting people buying properties and renting them out or whatever the case may be. It's gonna be hard for them, man.
Mm-hmm. Now
and
go ahead,
when it's time to get rid of people, you spoke on it's a fee for the landlord. He don't. Not only my understanding, not only does he have to go to court to get them out, but he's gonna have to pay that fee and give them 4 months rent, up to 4 months rent. So
then
that's gonna wipe a lot of people out, man.
And then, Bill, think about this. Now, if a landlord go up on me, if I unconsciously like that, say, no, that's too much, the landlord got to buy me out. In a sense. Hold on, let me pull it up. Read that then. Yeah, because I read that. Let's see. Let me see what it says. I read it on here. Let's see. All right. Here it is. Now read it. Informal rent control framework. At the time of the lease renewal, if a rent increase is deemed unconscionable by a tenant, they would have the right, Bill, to reject it and demand relocation payments equaling 4 months rent or more. Do you hear that, Bill? Bill, you're right.
And guess what, Martin? Just what you just said. This gives investors, say for instance, a couple properties off of 63rd and Halsted. And they know, because they got contact with zoning and planning, they know they want that property.
Mm-hmm.
So they're going to go up and the tenant, of course, if you go up $10, they don't want it. But they rather give them that 4 months rent, not a building vacant. And if the building vacant for any months, most landlords can't stand for a building to be vacant for no 3, 4, 6 months at a time.
Mm-hmm.
But we know who can, and they will give that money up because they know already that they get ready to do something with that property, that land, and it gives a chance for them to move other people in, other nationalities, because those Latinos, they ain't gonna complain too much. They'll move in and move 3 families in and pay the $1,500.
Mm-hmm. Wow.
It's all by design, man.
Bill.
It sounds
Man,
good.
yeah.
It sounds good.
Yeah. But you know what, Bill?
It gives the tenant a lot of right.
I think we should revisit this topic, man. I need to study this topic, man. I really do. I mean, I'm basically here in the blind. I think we need to revisit this, Bill, because we need to. I mean, it's a lot of language that we probably don't understand. What they call it, verbiage.
Mm-hmm.
Yeah, we don't understand. I got to sit down and listen. Reread, look up some words. So you could tell your landlord if at a lease renewal, and if you don't like the amount, if it's deemed unconsciously, you can reject it and demand him to pay 4 months rent or more, relocating fees. Ooh, my goodness, man. That's going to knock off the small man, period. The flipping by.
Yep.
Mm-mm-mm.
Yep. And then they give somebody else a chance to come in
Mm-hmm.
of another rate.
Yeah.
I'm gonna keep it. I'm gonna keep it a buck. And you don't want to pay the $1,500? Okay, I'm gonna give you this $5,000. You to move on. And please believe a lot of these people that here illegally or whatever, they're gonna have vouchers.
Yeah. Yeah. But see, my thing is that you brought it to light. This is going to benefit the big investors.
Yep.
It's going to knock the small man out,
Yes,
if I may
it
use
is.
that term. Don't give me no disrespect to people that own property out there. I may call this small man, but you know what I'm saying. A small man versus a corporation. You know, that's what I'm saying. So
Yeah.
no disrespect if you buying and flipping homes and rehabbing and all that. No disrespect. That's what I'm saying. So Bill, I think I'm gonna get off here because I got to move some things around.
All right, Mike.
You know what, Bill? I might send you a couple of these links, and man, we got to read up on this stuff, man. This is real. I want to thank Teamwork Inglewood, my one of my bosses, Mark Mitchell, associate director, put me up on this. I mean, he told me to talk about it. He actually gave me the article. And I found it, sat down and read the article there and looked over. I was like, man, it's going to be a lot of changes. And what really saved them, actually, this was going to be effective July 1, 2026, but they moved it. So it's going to be effective January 1st, January 1, 2027. So, man, it's a lot, man. We got to study this, people. We got to see what the hidden hand is.
And it's going to affect the urban area.
Yeah.
The places where they went up, all of the neighborhoods that they went up, raised those taxes, those are the neighborhoods that they target. That's why they did it in the first place.
All right, Bill. We're going to leave it right there. All right. Thank you. You already know what it is. Live, uncut, unedited. Tell the truth. And what? And shame the devil. I love being black. All right, people. We're going to, we got to revisit this. We definitely going to have to revisit it and study it, read it over and reread it, so we can know the one. But it's going to be a lot of game in this, boy. It's going to be some people that's running game, boy, running game on these landlords. But it's not for me to say. I'm just here posing the question, what do you guys think? That's it, about this new ordinance. I think it's H something. Let me see what it is. Let's see what it is. All right. H Bill 3564. Thank y'all so much for tuning in. I appreciate you Thank you for the prayers. Thank you for the support. Thank you for the love that you guys showing me. Thank you for walking up on me, having courage enough to walk up on me and take a picture with me. Thank you for all that, people. I don't want to leave no stone unturned. I'm grateful. And it's good to be living in the land of the living. So we're going to revisit it, people. Again, thank Mark Mitchell, Associate Director here at Teamwork Inglewood. Myself, Martin G. Johnson, is a navigator. So I'm bringing this in conjunction with Teamwork Inglewood. Thank you, guys. Thank you, guys. Thank you so much. And I'm out of here.